Most personal injury cases settle before they ever see a courtroom or ever go to trial. But why? Well, it's about risk versus reward. There are risks on both sides. For plaintiffs that we represent, it's a risk that we could have a jury who doesn't like them, or a jury who is cheap and doesn't want to give them the damages award to compensate them for their injuries. In contested liability cases, there's always a risk of a jury finding that our client was at fault or partially at fault, which could nullify or reduce the damages award. On the defense side, there's the risk of a very generous jury who is willing to compensate someone fully for their injuries. And then there are costs. Both sides have costs of taking cases to trial. When you have expert witnesses like doctors, accident reconstructionists, etc., they bill by the hour and they are expensive. So most cases settle because it makes sense. It makes sense that both sides want to avoid risk and find a number that they can both walk away from the case for. It might not make any sense, but the sign of a good settlement is that both parties walk away a little disappointed. Plaintiffs walk away taking a little less than they had hoped for, and insurance companies walk away paying a little more than they had hoped for. Again, it might not make the most sense, but that's the sign of a good settlement.